Hi, Amanda.
Hi, Josh. What are we talking about today?
I thought we could talk about sexual assault and sexual harassment, obviously, some very serious topics, and forced arbitration of sexual assault and sexual harassment claims. So, as it currently exists in the law, employers can impose arbitration on most of their employees. Arbitration is a private process of dispute resolution, it's like a private lawsuit, and this can keep people who have experienced sexual assault or sexual harassment in their workplaces from being able to get into court and tell their stories publicly, which is something that lots of Connecticut employees who've been treated this horrible way want to do. But that seems like the law in that area is about to change. Tell us about that.
Yeah, this would be a really great change. So what happened at the end of last year on November 4th, 2021, the Senate Judiciary Committee voted unanimously to advance a bill called S2342, which is aptly titled Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. Now, this isn't the law of the land yet. It now needs to move on to the whole Senate, where it has to receive a majority vote before it could then be sent to the House of Representatives. Then, of course, it would end up on Joe Biden's desk. We do think, though, if it does, that it is very likely to become law because President Biden has already indicated a desire to end forced arbitration. So this bill is of particular importance because it's bipartisan. And as we know, in the world we live in right now, that's pretty hard to come by. So we have senators on both sides of the aisle who are working together to try to eliminate this mandatory arbitration agreements in civil cases of sexual harassment and sexual assault. So what does that mean? Unfortunately, sometimes a lot of people take a job and they sign at the beginning of their employment an arbitration agreement. And the arbitration agreement says, look, if a dispute comes up in the workplace during your employment with this particular company, you don't have access to the courts. You have to arbitrate those disputes. It's interesting, Senator Sheldon Whitehouse, who's a Democrat in Rhode Island, actually pointed out that these mandatory arbitrations aren't just keeping the sexual harassment and sexual assault complaints in arbitration, they're keeping them quiet. They're not public, right? So it's not just mandatory forced arbitration, it's actually mandatory forced secret arbitration, which has had the effect in the workplace to embolden these sexual predators because they can do these harmful and terrible acts within the workplace and the public never finds out about it. This bill, if it actually does become law, would end that, which would be great. The bills have largely been spearheaded by Gretchen Carlson, who a number of you might recall was the former Fox News anchor. She had a high-profile sexual harassment lawsuit against then Fox News chairman and CEO Roger Ailes. Her organization, Lift Our Voices, has this goal of eradicating forced arbitration in the workplace, and it has really gotten a lot of legs since the Me Too movement. You might remember back in 2017, some big companies started taking these forced arbitration clauses out of their agreements for issues resulting from sexual harassment or sexual assault. So we're moving in the right direction. These are definitely positive changes, not only for Connecticut employees, but for employees across the country. We're not at the finish line yet, but we're definitely moving in the right direction. Keep your eye on this.
Thanks so much for the update, Amanda.